Ready? Exercise number 20. Start. The scope of judicial data is much greater. It can be used to design more efficient caseload management systems, inform resource allocation in courts, and improve judicial efficiency. Unfortunately, this may not be as easy as it seems. Stop next para. NJDG is a subset of the e-courts project, a scheme launched in 2007 by the Ministry of Law and Justice. The project aims to integrate technology with the judicial system. However, a recent study by the National Institute of Public Finance and Policy under bracket NIPFP bracket out found that e-courts data lacks in several aspects, which may make the recent Supreme Court directions difficult to achieve. This is not a new issue, and the Law Commission of India has also faced challenges while depending on judicial data to calculate the case load across various courts. Stop next para. In particular, the problems in the data arise due to three reasons: inconsistencies in what is reported, missing data, and restricted access. As an example, the NJDG records only 24 case types. This is the form in which the final data is presented to judges, litigants, and researchers. However, district courts often record up to 100 case types. This means that data has to be retrofitted into the 24 types, which leads to inconsistencies. This is exacerbated by the fact that courts often don't tag cases under the law in which they are filed. They only mentioned procedural laws like the Evidence Act and the Code of Criminal Procedure under bracket CRPC bracket out, which renders the information unusable. For example, while abetting suicide is governed by the Indian Penal Code, the CRPC governs the procedure for prosecution. However, the CRPC governs the procedure for all criminal disputes under bracket theft, assault, etc. bracket out. And when a case is only tagged under the CRPC under bracket as it often is bracket out, it is impossible to identify what is the nature / subject of the dispute. This prevents high courts from accurately assessing the type of cases that subordinate courts hear and how long it takes to dispose of them. Stop next para. One could also analyze which cases are prioritized during the listing process by measuring the time between filing and hearing. Lately, the judiciary has faced questions of how to efficiently list cases and ensure that cases which need to be heard urgently are not delayed. Knowing how cases are currently prioritized can be crucial in addressing these concerns. Stop next para. Besides content, ease of access also restricts how the data is used. Even if the data were standardized and made error-free, the code design of the system limits its usability. Information can only be procured for individual cases because the system is designed to provide information to litigants and advocates. If high courts are to use ICT tools and ensure access to justice, they will require bulk data. Apart from the judiciary, researchers and civil society organizations can also benefit from such access. They can give insights regarding the performances of judges and assessing which laws led to more disputes. An empirical analysis could help corroborate their findings. Countries such as the United States and the UK are not averse to sharing bulk data and even have dedicated bodies tasked with the research and improvement of the judiciary. This is similar to the solution adopted by other countries. The e-courts project is a step in the right direction. Stop. Thank you very much.